Good morning, everyone, and welcome again to the JBDC Virtual Biz Zone. My name is Sansia Campbell, and I am the Partnerships and Events Coordinator here at the Jamaica Business Development Corporation. This would, of course, be our first session back since the passing of Hurricane Melissa, and I just want to extend our best wishes on behalf of the JBDC to all our entrepreneurs in the room this morning. Hope you weren't too badly affected, and if you were, that you will be back on your feet in no time. This morning is actually a continuation of a series that we started back in early October. It would have been our debt management series. And of course, it was a two-part session. But unfortunately, on the day when we were supposed to have the session, Hurricane Melissa arrived. And so we had to push it back. But gladly, the Office of Government Trustee has agreed to come back on with us and just complete the session for us. So I have with us this morning Miss Brittany Savage. And I'm going to tell you a little bit about Miss Brittany Savage. She is a graduate of the University of the West Indies and the Norman Manley Law School, where she attained her Bachelor of Laws and Legal Education certificate, respectively. She was called to the bar in 2022 and has garnered over 2 years of experience in insolvency administration as the Director of Insolvency Administration at the Office of the Government Trustee. And as I intimated earlier, we're going to be completing our debt management series. So today we are going to be focusing on business rehabilitation under the Insolvency Act. Please feel free to ask any questions that you may have. Drop your questions in the chat, and Miss Savage will be more than happy to take your questions. As is customary, the session is going to be recorded and it will be available on the JBDC's YouTube page. So, without further ado, I'm going to hand over to Miss Savage and she will take you through this morning's presentation. It's over to you, Miss Savage.
Hi, good morning, everyone. All right, so good morning again. It's an honor to be able to present to you. We at the Office of the Government Trustee, we're very passionate about businesses, about ensuring that all possible options available to business owners, to individuals, they are aware. And we know that a lot of persons might not know about us. And so we love initiatives like this. And so really applaud JBDC for giving us this platform in order to provide this information to you. As Ms. Campbell would have mentioned, feel free to ask any questions. I anticipate that there will be a lot of questions because, as I would have said, OGT is not known to a lot of persons, and so I anticipate a lot of questions due to that. Okay. So throughout this presentation, we'll be dealing with the business rehabilitation under the Insolvency Act. And through that, we'll discuss the options available under the Insolvency Act, which are proposals and bankruptcy, the administrative process, as well as the benefits of this regime. Now, all of this comes from the Insolvency Act 2017, which seeks to provide an efficient and effective insolvency regime that promotes economic stability. So it encourages entrepreneurship, which I'm sure a lot of persons would be glad to hear, considering it's about business rehabilitation, and to maintain investor confidence in our economy. Without putting or giving these businesses this chance, the country is going to fall apart, the economy is going to fall apart. So at the heart of this act is businesses. Now, I'm sure you're asking, we hear it when we go into the streets, who's the government trustee? What's the Office of the Government Trustee? Now, the OGT for short, it's a public office for which expenses are paid throughout the consolidated fund. Now, when you consider business rehabilitation, a lot of persons would love to hear this because you ask, am I going to have to pay you? And the short answer is no. you don't have to pay our office because we consider ourselves we've been called the legal aid of the insolvency regime, in that we're paid through the council fund. So the businesses don't incur that cost. And we have the same powers, the same responsibilities as a licensed trustee. We don't have a licensing requirement, but because we're not licensed trustee, we don't carry the cost or the fees that are associated with licensed trustees. But we don't just act willy-nilly. We don't just act amok. We are held to, our decisions are questionable. They can be brought before the court. And we also have a regulator, the Office of the Supervisor of Insolvency, where you'll be hearing throughout this presentation the stakeholders involved under the Insolvency Act, and those OSI is one of them. So how to access business rehabilitation under the insolvency regime? Firstly, it's most important to answer the question, who can access it? That's an insolvent person. No, an insolvent person under Section 2 of the Insolvency Act is a person who resides, carries on business, or has property in Jamaica. You're required to have debt of no less than $300,000, and you have to be unable to meet these obligations as they become due. To break that down, particularly where the obligation aspect comes into play, it's, say, for example, you're carrying on business or simply an individual, and you find yourself where 1 month the debt collectors are calling you, say the business doesn't turn out as much profit as you anticipated. You can't pay your light bill, you can't pay the water, you can't pay your employees. You now found yourself in a position where you can't meet your liabilities as they become due. And where it is that these liabilities amount to $300,000 or more, that's now where the act considers you an insolvent person. And a person doesn't necessarily need to be an individual. It can be a partnership, an incorporated association, it can be a corporation. The act, everybody falls under, and everybody can fall under the terminology of person. And when you find yourself in this position, where do you go? Now, you will then turn to where it's voluntarily, you go through the Office of the Supervisor of Insolvency. Now, as I would have mentioned, the Office of the Supervisor of Insolvency is one of the stakeholders or important persons under that legislation. And we consider them the starting point for any matter. So whether it's proposal, because that's one of your options, and assignment for the benefit of creditors. And that's just a fancy way of saying bankruptcy. And don't get too nervous about the term bankruptcy. I'm here to show you that bankruptcy is really not the stain or the scary monster that everybody considers it to be. And so the starting point, as I mentioned, is OSI. Now, because these are voluntary, where it is that you find yourself meeting the criteria of being an insolvent person, you would apply to the Office of the Supervisor of Insolvency. They will now assess your situation. You bring in your documents, so bring in any loan agreements that you have, any statements that are showing that, hey, payments are outstanding. A few months have gone by, and I'm now owing $300,000 or more, and I cannot meet these liabilities. The OSI will do their assessment, they'll do their investigation, and they will determine which method is best for you, whether it's proposal or whether it is that bankruptcy really is the better choice for you. And in doing so, they will make note of the fact that certain persons or certain class of persons, a proposal would be best for you because you can't technically hold these positions and be a bankrupt. Now, the legislation that governs security officers, it does not allow you to also be a bankrupt. Certain licenses, such as real estate license, you are unable to hold these licenses while also being a bankrupt. And as such, and there are also certain entities that, though their legislation don't prevent it, they have made it clear that they don't believe that bankruptcy and their entity mesh well. And as such, when you go into the OSI, they'll assess all of this and determine which one is better for you. And in those instances, a proposal will be best for you. Now, what I've discussed voluntarily, but sometimes it's not you going and say, hey, I see that I have a problem and this is the solution. You're not the one accessing the regime yourself. So your creditors themselves can also seek to put you in bankruptcy, so to speak. And this is done by way of a receiving order through the court. So where it is that they know, they can provide the court with evidence that an act of bankruptcy has occurred. That is, you've owed you have a liability of $300,000 or more. You're an insolvent person. They can have the court adjudge you bankrupt. But this presentation will mainly focus on entities, businesses accessing voluntarily the regime. Now, a proposal. Now, this is an arrangement with creditors for a compromise in the amount owed or extension of time in which you want to repay. We've seen in the office where many times it's not a matter that you don't want to pay back the money, or it is that you absolutely cannot pay back. It's just that sometimes, whether it's interest rates, whether it's the time in which say they want you to pay it back in 6 months, but you know that in 12 months you could realistically pay back this figure. So you really just need more time, or you really just need to shave off, say, 20% of the debt, etc. And that's where a proposal would be best for you. So it's really just an agreement between your creditors in which you determine the best terms to satisfy the debt. And this is, so what you would do is, and you're not doing this alone. It's firstly with the OSI and then where the government trustee comes in. So where OSI determines that the proposal is best for you, having assessed, this is usually where you just need more time. It's not a dire situation, you just need a little bit more time, or you just have a percentage here, a percentage there could be shaved off. So a notice of intention for a proposal is filed and through the government trustee, and the government trustee will do further administrative steps to ensure that your proposal is sorted out properly. We wear many hats, and one of those hats is formulating a perfect proposal. So throughout the proposal process, firstly, we conduct our investigations into, this is bankrupt, but into the debtor's assets, because at this point you're not considered a bankrupt because it's a proposal. So we conduct investigation into your assets, review and admit the creditor's claims. Now this has broad brushed quite a few steps, so I'm just going to take a moment to guide you through it. Now when we say investigation, you will bring in documents to prove what assets you have. Many times the asset in question is your salary. So we'll assess your salary. We'll have an examination on the oath in which it's just like court, but it's in our office. You give evidence showing your expenses, your salary, and all of these factors are considered. The responsibilities that you have, whether it is assessing the businesses to see how much money the businesses the profit of the business, considering from your standpoint, how it is that you came to have incurred these liabilities, how is it that you found yourself now needing a proposal, and we will assess all of that, and all of this is in aid of formulating a proposal to put before your creditors, because we are here for you, but we have to put forward a truthful proposal because you are signing to it, you're giving this evidence on the oath, and really and truly, you're asking your creditors to consider this proposal. So we have to ensure that our due diligence is done and that the evidence that we put forward is correct. So we also review and admit creditors' claims. So here it is, we will reach out to the creditors, you declare the creditors, we'll reach out to them and review their documents, so the loan agreements, the statements, and many times we'll find that the interest rate egregious, where there, and also creditors, it shouldn't be, but they are more inclined to be more considerate to say give a discount here and there where it is that an entity is involved. So we review the claims, we determine it at the rate that is under the legislation, and that's the amount that we admit, and that's the amount that determines, that forms the basis of the proposal, and that's the amount that we will pay back. So in formulating the proposal, we would use the evidence that we gathered and we put forward the information. Now, this proposal will include name, job, age, all the factors that are important, your expenses. We detail your expenses to your creditors so they can see where exactly where exactly the money is going, as well as your salary. And from that, we will determine how much it is or what are the terms of the proposal. Most times, these terms would include, say, you will pay $20,000 a month until each month for a period of time until we then facilitate the payment of a dividend. Now, the money that we collect is placed on investment. And so where we hold it for a year, 2 years, that money will then it will attract on investment. So we'll get more money, and then this is what we'll pay out to your creditors. Now, after this proposal is formulated, we'll then have a meeting of creditors because it's very, very important that the creditors accept what we put forward. So whether the terms are they're in agreement with the terms, and whether it is that they're actually interested in a proposal. And where it is that the proposal is accepted, we then go forward with satisfying the liabilities. There are other administrative steps that we will go through, but more so I'll go deeper where it's on the bankruptcy, because there's some meeting points. There's some general things that we do under both proposals and bankruptcy. And after we have satisfied the liabilities to the creditors, then we will issue a certificate of full performance. And that certificate of full performance simply says that you've done everything that you agreed to under the proposal, the creditors are satisfied, and as such, the regime worked for you. You are now off to continue your business, continue to, if it is in order to further the business, to get more loans, etc. And this is served on the debtor and the supervisor of insolvency. Now I'm going to go into bankruptcy. Now there's some similarities with bankruptcy, but most times it can be a voluntary process, but this is done by way of certificate of assignment. I'm going to show you a certificate of assignment as we go along, and this may happen where bankruptcy was chosen for you, where it is that having assessed your situation, we realized that we could not formulate a proposal that a creditor would accept. So sometimes the debt is much more significant than where it's in a proposal, or it is that the amount that you can pay back versus your debt, it's not proportionate. And where this happens, or also where it is that the proposal is not accepted, then that's where bankruptcy comes into play. And I know I'd have stressed it. I'm not sure if some of you would have seen at other JBDC initiatives or other Ministry of Industry, Investments and Commerce initiatives. Bankruptcy does get a bad rep when you see it in media. It's never anything good. Nobody wants to be called a bankrupt. Nobody wants that to be attached to them. And it's not, having worked at the office of the government trustee, before I too would be skeptical, but having worked here and having fully immersed myself into the insolvency regime, I see now that it really is a tool, and that's just not a catchphrase. That's nothing. It can work for individuals. It can work for business. You can come out better because of this. So the administrative process for bankruptcy, you will note that some of these things are similar to the proposal. So there might be some crisscross. I'll take you through it. So where it is that the OSI provides our office with a certificate of assignment, the first 5 days we consider to be the most critical. Now, this is where we would have to publish a bankruptcy notice in the paper. I'm not sure if any of you guys check out the legal notices in the paper. You will see certain things in that section that are published by our office. And one such thing is the publication of the bankruptcy notice. In it, I have a believe I have a copy of the publication. This is the publication. And in it, it was simply detailed that so and so is now bankrupt and that a meeting will be held. Now, during this first 5 days, we'll also take steps to investigate your assets. So we'll send out over 100 search letters just to see if there's any assets out there. Sometimes, whether it's for whatever reason, the business will have assets that were not listed in the statement of affairs, and it was not declared by the bankrupt, and as such, these would form a basis of actually satisfying the creditor's liabilities. Additionally, we will set a date for the examination under oath. We will also contact the bankrupt. If it is the directors, we'll contact the directors. If it is an individual, we'll speak with the individual, set up a date for the initial interview, just really smoothen the process so that, and just to assay some fares, anything, we try to get it out of the way within these first 5 days. Now, where it is that we have our examination on oath, similar to under the proposal, it's just gathering evidence, gathering the information about your expenses, your responsibilities, your salary, so that we can determine the surplus income. Now, we have seen that it's very unfortunate, but a lot of persons that come into our office, they don't actually have any form of assets, so to speak. There's no real estate, no shares, no anything like that. And so rely heavily on the collection of the surplus income. When we determine the amount, we would look on the expenses and say, for example, your salary is $100,000. Your expenses come up to $80,000. The trustee will then determine that on that basis, you can put towards your satisfying your creditors, say $15,000, given a little bigger room to, if anything come up, if you have to buy a bubble gum, if you have to go and cut your hair, something, we do give wiggle room because the legislation provides for it, and we're not heartless. We understand that it's not anything wrong done that has led you to here, and that doesn't mean that you shouldn't be treated with humanity. And so we allow you to have enough for a reasonable standard of living. We also conduct a site visit. So whether it's a site visit of the registered office of the business or a site visit, which is the residence of the individual, just to see if there are any other assets that must be noted, confirmed assets. So where persons would have noted that they have a motor vehicle, we would assess the motor vehicle to determine if the documentation provided, if it matches up, as well as determine the quality of living, etc. And all of this comes together to form a preliminary report, which we then present to the creditors at the first meeting of creditors. It's here that we would have assessed, told them everything that we found out through investigations, whether it's any information gathered from TAJ, etc. And now persons being considered this invasive, but it, not to say it really isn't, but it benefits you. Many times persons would overlook certain things. We've had examination under oath or investigations where it's only through prompting that a person would realize that they should include the fact that they have medical illnesses, because you have to provide for them to be able to purchase medicine, but various other things that you would have overlooked or you would not have thought that bankruptcy gives consideration to. As well as when it comes to your illnesses, this is something that the creditors ought to know. We've had many instances where creditors would have written off debt or compromised on a figure due to the fact that the individual has these illnesses. And so it's very important that you provide us with this information so that we can use it to the best of our ability to ensure that the creditors or the insolvency regime benefits you to the best of our abilities. As I would have mentioned under proposals, we do review the claims of the creditors. Now, I'm going to go into the pros and the cons, but I will mention here that a benefit of bankruptcy is that, as I would have mentioned, many times we sign these agreements and you need the money. The truth of the matter is you need the money. I know when I was getting student loan, I never read it because I needed the money. I said, well, anything I'm signing, I could just sign it. And likewise, when we have bankrupts or when we have debtors come in, they're very forthcoming to say that they didn't read the agreement and their terms, and you not realize that some of the terms that you are signing to are contrary to various legislation. We have the Money Lending Act, which dictates how a loan agreement ought to look between for certain institutions. The information that must be presented to that must be brought to the individual's attention before they sign it. Likewise, for businesses, these agreements, there are certain key things that ought to be there. And these microfinance, these entities, they are very much aware that when they're giving out these loans, that the people ought to know, and therefore they should structure their agreement in a way that provides this information to them. And so where that doesn't happen, we will assess these claims, we'll assess agreements, we'll assess the statements. If they're, or accountants, they're looking for everything. So if there's a month where, say, the interest amount should be, it really should be adding $2,000, but I don't know if it's a glitch in the system, $3,000, whereas a not whereas a layperson, sometimes me looking at this, you would not have noted that, hey, this is not correct, and this would then lead to late fees, etc. That really and truly you ought not to be paying this back. So when you get a statement that says, oh, you borrowed $300,000, but for whatever reason you're now paying back $1.5 million, and you just say, well, who am I to question it, or what power do I have to question it? Under the insolvency regime, we question everything. If it is that we have to go back to these creditors 600 times, we're going to go back to them 600 times and then 601. We are going to assess everything to ensure that the amount that the trustee determines to be admitted for payment is the amount that you ought to be paying back. And there's no hidden fees that you did not agree to that is being applied. And so where it is that after we've assessed it, we've applied, interest also stops at the date of bankruptcy. And so where that happens, you would then modify the amount admitted to reflect this. I would have mentioned investing monies. The money is placed on investment. So it's not as though it's sitting down, where if in your bank account, say after how long you seen 0.00001. No, the money is placed on investment until we determine that at a certain point to pay dividend. Where you speak to anybody at OGT, we will throw out the term 5 cents in the dollar, 10 cents in the dollar, 12 cents in the dollar. Really, it just means that we are paying 5% of the total admitted liabilities, 10% of the total admitted liabilities, until we get to a point where we have satisfied the totality of your liabilities or a sum agreed on. We also facilitate financial counseling. The fact of the matter is, a lot of us weren't equipped with the tools in which we need to manage our money. And I think I'm going to take the time here to particularly point out that it's a reason why we love partnering with the JBDC, because it's very important that persons who are seeking to enter into businesses are given the necessary tools in order to manage business, a business plan. We would have had individuals who came into the office who, when we ask, how is it that you ended up here? You'll hear it time and time again, or they really had a passion to start a business. The heart was there. They just did not have the plan. And then where things end up snowballing, or it could be for a myriad of reasons. Just as I said, 1 month, they 1 month, the money that they needed to start up, they would have invested all this money into starting up the business. It doesn't yield fruit, or if they were using their salary as capital. So what happened 1 month when they don't get paid? I know a lot of persons in COVID would have, you could have said that you plan for the money that you're gonna get. I am guilty of that, where I plan for the money, not knowing that something could happen that could prevent you from getting your salary, and say yes, you're gonna get the money back. If it's there any error, you're gonna get the money back. But it's when you're gonna get the money after late fees have already applied, after they've already applied various penalties. And so these things happen. It really is just life. Yes, nobody wants to plan for things to go wrong, but as the government trustee will say here in the office all the time, that proper planning prevents poor performance. And nobody wants to plan for failure. But I'm sure that where it is that you've already planned for certain things, when they do happen, say for whatever unfortunate reason they do go wrong, you're ready, because you'd have already given thought, you'd already put things in place to say, what do I do when things go wrong? And many times when things go wrong, the insolvency regime is really should be your answer. It really should be where you are headed, because we do have the tools. The Insolvency Act provides the tools in which to assist you. And one such tool is financial counseling. First time bankrupts are legislatively required to go through financial counseling, learn budgeting, learn all various tips. But we don't end it there, where it is that we assess the situation and we determine that a particular set of counseling is needed for business owners. If it is that we need to um get you some courses, get you some seminars, etc., we ensure that we facilitate that. Sometimes the strain of just having various different money issues, we've had bankrupts come in, we've had individuals come in, whether they're bankrupts or they're just debtors, who they'll break down in tears because the strain of carrying all of these money problems, I don't think we're properly equipped for it, and it does take a toll. And so we do ensure that where whatever is necessary, we facilitate same. And once we manage to once we've collected sufficient amount, we've placed them on investment, we pull them from investment, we'll then pay out a dividend. Now, back to publication. We do publish when we intend to pay a dividend. You can look in the Gleaner and see our publications. I'm not sure if anybody's ever seen them and curious as to would them most of them are pay something. That's us. And so that is in a nutshell the administrative process for bankruptcy. There are many other things, but what I found in doing these presentations is that really and truly, no matter how much I give you, you're gonna have questions. So I prefer to just answer them through the questions, just to see where it is that if you have any curiosities, anything that you think might have any connection to your business, etc. And as I would have shown you, this is the certificate of assignment. This is how it looks. So it says that the debtor John Doe has made an application for assignment on this date, and it was filed on this date, and now the supervisor of insolvency has accepted has approved the application, and has also determined that the government trustee is a trustee of the estate. Now, as I would have mentioned, there are licensed trustees. So in those instances, it would read differently. But here, it's the government trustee. Additionally, I would have shown you the publication. So this is what it looks like. Now, this always is an attractive marker of bankruptcy, in that there's an automatic discharge. So first-time bankrupts are entitled to automatic discharge 1 year after your date of your certificate of assignment. And what this means is that after that 1 year mark, where it is that nobody has opposed, that is, the person is given the option, the trustee, the supervisor of insolvency, or your creditors, nobody opposes, you are then discharged from all debts. Now, Section 150 does note some debts which you are not discharged from, so student loans, maintenance orders, etc. But separate and apart from those listed under Section 150, your that discharge is automatic. I know a lot of persons would think, how are you gonna, how can you do that after 1 year? We've seen it. We've had persons where at that 1 year marker, we have provided a report at the 11th month, wherein we would note that the bankrupt has either fully satisfied the debt or is in a position to satisfy the debt, and as such, we have no issue with them being automatically discharged from bankruptcy. And where it is that an automatic discharge is not is refused, or where it is that it's not a first-time bankrupt, and as such, you will not have had that entitlement, they will then be where it is that they have satisfied the debt, say 2 years' time, we'll then have a notice of compliance prepared by the trustee and given to the supervisor, who will then assess it and issue a certificate of discharge. I do believe I have a photograph of a certificate of discharge. Here it is. So similar to the certificate of assignment, it will note that the bankrupt has complied with the conditions of the discharge. In this instance, there was a conditional discharge previously. So sometimes a conditional discharge would read, John, that it's recommended that John Doe satisfies 75 cents in the dollar, 70 cents in the dollar, 50 cents in the dollar. That's 50% of their debts before being discharged. And where that condition is met, the notice of compliance is prepared and the certificate of discharge follows suit. Now, the pros and cons. There's a stay of legal proceedings. What that means is, once it is that you have filed a notice of intention for a proposal or the certificate of assignment has been issued, nobody can, for any debt provable in bankruptcy or any debt provable under the Insolvency Act, nobody's allowed to, we can't bring any legal proceedings against you. So they can't file an application in court to recover funds. Everything has to come through the government trustee. Additionally, interest stops accruing on the debt. So where it is that 40%, that 50%, 52%, in some instances, 240% interest rate is being applied. Previously, once you come under the regime, it stops. And when our accountant is reviewing the claims, they're gonna calculate it, they're gonna note it. Further, this whole regime is here to provide a legal shelter. As I would have mentioned, what we found is not businesses or persons unwilling to pay back the debts owed. It's just simply that life happens. Life got to them. Even where you have a great business model, let's look at Hurricane Melissa. A lot of persons would, no matter how much they would have prepared for the hurricane, you can't stop a natural disaster. And as such, where these things happen, the insolvency regime is willing to assist you. Now, we have some cons, because nothing in life is perfect. However, these are geared towards bankruptcy. And where it is that somebody has declared bankruptcy, they can't be the director of a company. That doesn't mean that they can't carry on a business. Additionally, as I mentioned, the notice is published in the newspaper. We're very much aware that that is not something that persons would immediately want to happen. But the fact of the matter is, it does give the creditors an opportunity to file a claim, to reach out, to say, hey, this person owes me so and so, this business owes me so and so. But on the flip side, just as how the bankruptcy is published, the certificate of discharge is also published. So the world is going to know that the debts are satisfied. This person has fulfilled the terms under the insolvency regime and has paid off their debts. As I would have mentioned, bankrupts also can't hold certain licenses. So private security license and real estate license, they're prohibited, as well as there are certain entities that don't like the look of it, which we are endeavoring to do more education platforms to highlight that bankruptcy is not anything crazy, it's nothing scary. It doesn't devalue any body or any business. It's just a status that you've accessed the insolvency regime and you're taking steps to ensure that you satisfy your liabilities. And so this presentation went by very quickly, but I do anticipate that the questions are coming in and I'll take some time to answer it. But to conclude, the OGT seeks to administer matters within the modern framework of the Insolvency Act and to provide a comprehensive and rehabilitative service for individual and companies that are in financial distress. We are here to help you. We intend to continue these initiatives to ensure that the public is aware of the options available to them. We want more persons. People say nobody really wants more work, but the fact of the matter is, when we go out, we hear so many persons say that this could have really benefited them, and they know persons who this could have benefited. And where it is that you catch it early, as I would have mentioned, $300,000 or more. There's no need to wait for it to be at $1 million, $2 million, $69 million. There's no need for that. Once it is that you find yourself meeting the criteria of an insolvent person, reach out, even if it's just for a consultation, to say, hey, this is the situation I'm in. Let persons who are familiar with the regime assess your situation and determine that, hey, this is the best option under the act that will work best for you. Better we'll look on it and we'll say, no, you're worth for nothing, rather than you sit there and things snowball and you find yourself in dire need. So thank you so much. I am gonna open the floor. I'm not sure if Ms. Campbell can assist me with the chat so that I can see any questions and I can answer them while I'm here.
Yeah, man, I can assist you.
Thank
So
you.
Tashari is asking, can you please name a few of those agencies other than real estate and private security? Remember the list of persons that you had mentioned that
Mhm.
were not allowed to be
It's
bankrupt.
so, as I would have said, anybody who securities license. The act is slipping me right now, but it's a particular act in which it precludes persons who hold the licenses under this act. So any private security, you name it, I won't name it, but any private security firm group where you hold a license with them based on the
So would
act,
that
you
be the
would
owner
have
of the entity or an individual employed to the entity?
what it is that they hold the license. So that
Okay.
securities license, you are unable to hold that license, carry out the functions under that license whilst being a bankrupt.
Okay. All right, Tashari, I hope that answers your question. I don't see any other questions in the chat at this moment.
No other questions. Does that mean the
Okay, yes,
presentation
there's
was
another
fabulous?
one. There's another
Okay,
one. Can civil servants file for bankruptcy?
absolutely. I want to say of our more recent matters, 90% of them are civil servants. So
Wow, that would be
come,
like me and you.
me and you, we're
Wow.
filing for bankruptcy. We're accessing the regime.
Okay, and just to clarify, this is open to both individuals as well as small business owners, big business owners, just about anybody who finds themselves in that position.
Yes, the Insolvency Act allows for insolvent persons to include a myriad of individuals. So actual individuals, businesses, whether it is that you're trading as sole practitioner all of that. So
Right.
trade-off,
Right.
that's for you.
All right. Okay, someone else is coming with a question. In the meantime, though, Brittany, if you could just share your contact information so that persons who may not think of the question know, right?
No?
Yes. So that's the contact information right there. So there are a couple of questions in
Mhm.
the chat. So the first one says, what are the different loans that the act applies to? Car loan, rent, etc.
All loans, car loans, um, trust me, my brain is not buffering it because we see them all. We've had loans with pawn shops. We've had
Mhm.
motor vehicle loans, those unsecured loans where you see the sign say, come in, you can get a loan in 10 minutes. All
Wow.
of those loans
Okay.
are quantities that you met the requirement of liabilities $300,000 or more.
Uh-huh.
All those loans. Rent, yes.
All right. All right. So
Taxes,
since we said there are no questions, there are a couple of big questions that came in. So let's go again.
mhm,
Can actions and decisions of licensed trustees be modified or reversed by the court?
yes. So
Okay.
Um, the first point will always be the regulator, the OSI, but where
Hmm.
it is there's any decision that somebody just wants to question, the court is available.
Okay. And could you share what sort of amendments the court has made in respect of the OSI decisions?
OGT, um, none is coming to mind, but I can give an example. Say for, and it's not necessarily an amendment, but we have in the past opposed, so would have
Hmm.
opposed the discharge. And where would have opposed the discharge, would have opposed it outright. So there would be no conditions. There have been instances where the court has determined that apply conditions. It falls under the whole framework that the act is for rehabilitation. It says it's to preserve viable companies, rehabilitate debtors, and under that backdrop, there have been instances where the court will look on the situation and determine that outrightly opposing or opposing until reach a point where the creditors can decide is not best, and we should set a figure. I believe last year or the year before,
Hmm.
time is crazy right now, but the court would have determined that a bankrupt that we had should pay, having considered her illness, her expenses that would have accrued due to this, the amount she had paid thus far, which I do believe was 50 cents in the dollar, so 50% of the debt, that should have been that should be accepted as full and final, and her debt would be satisfied. So
Right.
decisions like that.
Okay. All right. Another question. With the passage of Hurricane Melissa,
Mhm.
what are you seeing on the ground with debt management and persons applying for the services of the OGT?
What a timely question, because we are just now we're going out. A group of our officers would have gone out today to get some feedback to see how best our office can suit us. But from what we've gotten from other persons who are already accessing the regime, they are severely affected, and our office is willing to assist. We would have had a bankrupt just last week, would have
Mhm.
indicated of some of the damage suffered, and we would have immediately met with the creditors. The trustee would have met with the creditors and determined from her authority that she's gonna suspend the surplus income paid because this person needs some time to catch themselves, to assess the situation, to get back on their feet. So these are just certain things that we can do under the legislation in order to protect our debtors.
Okay, great. And then, are you privy to say the average number of bankruptcies granted per year in Jamaica?
I wouldn't be able to say granted in Jamaica, because
Mm-hmm.
as I would have mentioned, while we get matters from the OSI, we don't get all the matters. There are private trustees. So I could only tell you the number from my standpoint, and I could say on average receive, say, 18 to 20
Mm-hmm.
individuals
Right.
yearly. You'll see some years where there'll be higher numbers, and then you also have a period where there's a drop. But we would have noted that recently, I believe, I want to say late last year, we noted that having got after going out, having a string of road shows, these initiatives, that we did see an like for over a 6 month period, we noted an increase in the persons coming in. So where we would have had would be getting an one new matter, would have three new matters. Once we had one day we got two new matters. So you'll notice an increase here and there. And
Mm-hmm.
we're just seeking to ensure that through initiatives like this, that as best as possible persons are aware. Would appreciate if persons would follow our Instagram, because we do post financial tips. I know the government trustee would have been on your previous session and she would have given you the signs to look out for, and as well as the tips that you can employ to ensure that you don't have to access the regime. But we also give you tips as to what happens when it is that insolvency is the best answer for you.
All right. So just quickly, your handle is OGT underscore Jamaica for all of your socials.
Yes.
All right. So everybody, OGT underscore Jamaica. And
And I'm going right now to make sure.
importantly, remember we said at the onset that this session is recorded. So if you
Mm-hmm.
know somebody that needed to have been on and they weren't here today, once it goes live, we are asking you to share it with them. And you can also share
Mm-hmm.
the previous session as well, because there were some really good nuggets in there.
Mm-hmm.
And the fact is that a lot of persons are unaware of the OGT and the OSI, and what you provide are critical support services to both
Yes. To
MSMEs and individuals.
tell a friend to tell a friend, there is,
Yeah, exactly.
we are here to help you.
Right. All right, couple more questions.
Uh-huh.
Can bankruptcy prevent future loan application or prevent mortgage loans?
No, there's no
Okay.
there's no thing to prevent you. We've had individuals who, after being discharged from bankruptcy, they have gone and they have accessed loans where it is that there's any, not that there's any issue, but say, for example, there'd be an institution, a bank that would have had a notation that this person would have bankrupt. They'll just call and confirm that, hey, we are aware of this. This person has been discharged. We do send out the discharge letters, but sometimes we know that these businesses, they take a while before it trickle down. But we've had no reports that anybody has been prevented. You continue to access credit because that's how the economy flows.
Right. And just for clarity, it's not once you've been bankrupt, then that's the end of you for the rest of your life,
It,
right?
it is not. It is not.
Right.
We're stressing that it's not this daunting process. I'm gonna just we've heard from bankrupts where they've come in. We joke about it all the time in the office. They'll come in for their examination on the oath. They're down. They're sad. They're crying. So many times they're crying. When you see that person 2 years down the line, a whole new person. We've joked about, like, no, that can't be John Brown that did come in here before. Because the fact
Mhm.
of the matter is, we take the stress off you. We've known persons who would have complained that they had these loan institutions calling them day in, day out. As we've had persons who said they're afraid to even look at their phones because the text messages are, they're just so bothersome.
Constant. Yeah.
None of that's under the insolvency regime. We take on the stress, we take on all those the callings under the legislation. Creditors are not they're prohibited from harassing or contacting the bankrupt. You can only deal through our office. So trust me,
Right.
this regime, it really takes the weight off individuals of businesses' shoulders.
All right, great. Thank you so much, Brittany. And thank you everyone for joining us this morning. As I said before, the sessions are recorded, so you can always visit our YouTube channel, search for JBDC Jamaica, that is one word, and you can subscribe and like and share because a lot of information is there, and you can just go and binge watch if you want to do so. So I want to thank you again, Brittany. And please
Thank you
extend
so
our
much.
thanks to Elise as well for joining us for the
Mhm,
sessions that we had this month.
mhm.
Ladies and gentlemen, it's been a pleasure, and we look forward to seeing you again next time. Have a great rest of the day.
Thank you so much for having me. Thank you so much for joining in. And we'll look forward to, if it's more questions through the email, we'll ensure
Mhm.
that we give timely responses.
Okay, great. Thank you so much, Brittany.